ಸರ್ ದೇಶಪಾಂಡೆ ಸರ್ ಬ್ಯಾನರ್ ಶೇರ್ ಮಾಡಿ ಸರ್.
Nagarjun sir.
Sir, good morning. ಕೇಳಿಸ್ತಿದ್ಯಾ?
Yes sir, yes sir. Good morning sir. Good
Okay,
morning.
fine. Yes.
Another 5 minutes sir.
Fine, sir. Okay, no problem. Yeah.
Good morning, everyone. Session will start in another 1 or 2 minutes. So I hope all of you have patience for that.
Professor
Sunil and
Professor Deshpande, we can start.
Yes, sir.
Yes, sir.
Uh,
Yes, sir.
Good morning, everyone. I welcome all the dignitaries and audience and students and my colleague professors. Today we gathered here on one occasion, that is national level seminar, that is on IPR initiatives. So here in SVC, we are working
Sir,
close with projects.
sir, excuse me. Please mute all others, sir, except the speaking, because many people they are speaking. Mute everyone and we can proceed, sir. We can proceed. So now you are also muted, sir. You are also muted.
Okay, I hope now I'm audible. Here in SVC, we were working closely with the projects as product.
Sir, again you got muted. Again you got muted.
Open it. I welcome Professor Sunita Rani to address the welcome address.
Thank you, sir. On behalf of Sri Venkateshwara College of Engineering, a premier institute in Bangalore, for Department of Mechanical Engineering, Department of Basic Science, IIC, IQAC, it is my immense pleasure to welcome all the participants and eminent speakers for the one-day national seminar on innovation and IPR, organized by the Department of Mechanical Engineering, Department of Basic Science, IIC, IQAC in association with CST. On this auspicious occasion, I heartily welcome our Honorable Chief Executive Director, Dr. Shashidhar Muniappa, sir, SVGI. I welcome you, sir. While in his busy schedule, sir could not make it, his presence. I warm heartfelt welcome to our respected principal, Dr. Nageshwar Gupta, M, sir. Sir, I welcome you, sir, for the seminar. I also would like to welcome our respected Dr. Sunil, Professor and Head Department of Mechanical Engineering, Dr. Srinivasa Rauke, Professor and Head Department of Basic Science, Dr. Nirmala S. Gupta, Dean R&D, Dr. Manjunatha N.K. IQAC Head. I welcome you all for the seminar. I welcome you all, professors. I feel honored to welcome our eminent speakers for today's seminar. Mr. Nagarjun MG, the coordinator, Kiran, IPR program, project associate coordinator, ITISC, KSCT. I welcome you, sir. I welcome you, sir, for the session. Mr. Gnanateja Bandi, a research assistant, DPIIT chair on IPR at the National Law School of India, University, Bangalore, IPR consultant. I warmly welcome you, sir, for the seminar.
Thank you, ma'am. Thank you.
I warmly welcome all the department of HODs of various departments, faculty members, participants, and technical and non-technical staff for the one-day national seminar. I welcome you all. I feel honored to welcome all for taking a keen part in this important program. I'm sure that you will feel enriched with the knowledge after the completion of this event. I welcome you all once again to the seminar, and I hope you all will have a great time ahead. Thank you. I welcome you all. Over to Sridhar Deshpande, sir.
Thank you for your welcome address, ma'am. Now I call upon Dr. Manjunath to say something about the SVCE and the initiatives of IPR in our college SVC.
Thank you, sir. Good morning to one and all. First, I would like to tell few words about our institute, Sri Venkateshwara College of Engineering, Bangalore, known as SVCA Bangalore, is one of among the best institutions in Bangalore, having 20 plus years of experience. SVCE is affiliated to Visvesvaraya Technological University, Belagavi, and approved by AICTE, New Delhi. SVC as accredited by NBA for Computer Science and Engineering, Information Science and Engineering, and Electronics and Communication Engineering branches, and also accredited by NAC with B++ grade, and QSI gauge overall ranking is gold band. SVCE has established Center of Excellence in association with Cisco, Honeywell, Blue Prism. We have MTech Structural Engineering, MBA in HR Marketing, Finance Specialization, and BE programs in Computer Science and Engineering, Computer Science and Engineering in Artificial Intelligence, Computer Science and Engineering in Cyber Security, Computer Science and Engineering in Data Science, Information Science and Engineering, Electronics and Communication Engineering, Mechanical Engineering, and Civil Engineering branches. SVCE Bengaluru stood in Band B, rank between 25th to 50 of Atal ranking of institutions and innovation achievements. SVCE has established Center of Curates to promote product development, research, industry interaction, entrepreneurship, and social responsibility. Coming to the about IPR initiatives in SVCE, IPR cell was established at SVCE in the year of 2018 with an objective to conduct various awareness programs on intellectual property at first stage and on the next level apply for the patents and IPRs. The objectives of IPR cell are to provide services related to patent search, patent drafting, commercialization, and inventions to create an awareness about IPR for industrialists, research faculties, and students, to impart training on patent filing process, to organize workshops, seminars, and awareness camps related to IPR, to promote better understanding of IPR to identify more IPs. SVCE management has taken lead to motivate ideators in filing their ideas by contributing complete expenditures. SVCE has filed over 20 plus patents since 2018. One of the filed patent is converted to product and marketing of the product is initiated. Out of 20 plus patents, 2 patents are granted, namely number 1, a converter cup for converting existing aquarium or aquaculture pond into an aquaponic systems. Number 2, apparatus and methods for producing biodiesel fuel. So this is about the initiatives taken by SPC and IPR. Thank you. Over to Deshpande, sir.
Thank you, sir. Thank you for your brief explanation. Now I call upon our beloved principal, Dr. Nageshwar Gupta, sir, for opening remarks.
Good morning, all. Respected resource person of the day, we welcome you once again for spending your time. And Mr. Nyanateja, the consultant, is helping us from the beginning in submitting our patents and up to examination. Our heartfelt thanks to you, sir. And I thank the resource person Nagarjuna sir also for this particular event. So this will create an awareness amongst all the faculty members and students in creating their own intellectual property rights and the design. So all these things will be discussed in a short duration. This will create an eye-opener session for each and every individual. Post that, we will support. We will be having handholding session throughout their tenure in various levels of their submissions. Thank you. All the best. Have a great day.
Thank you, sir. For our first session, first session keynote is done by Mr. Nagarjuna MG. He is a project associate and coordinator in KSEST, Bangalore. Mr. Nagarjuna is currently working as a project associate at Karnataka State Council for Science and Technology, IISc Campus, Bangalore. He completed his graduation in mechanical stream from KS Institute of Technology, Bengaluru, and post-graduation in stream of manufacturing science and engineering from Siddhaganga Institute of Technology, Tumakuru. He worked in various profiles such as graduate apprentice trainee at BEML Limited, Kolar Goldfields, quality engineer at Safari Designs Private Limited, Bengaluru, and also has a paper publication in both national and international journals. He participated as well as delivered lecture in many faculty development program workshops on IPR and biofuel. At council, he was mentioned the Bioenergy Research and Demonstration Center established by Karnataka State Bioenergy Development Board in all the 30 districts in terms of technical and administrative role. He was also coordinated the project of subjects project program biofuel, particularly kitchen garden development in Chamrajnagara district, which is funded by DST Vigyan and some other projects which are from NDRI funded by DST, that is from government of India, and where he is where there is a cooking oil is used, okay, as a biofuel. At a patent information center and technology and information support center, that is TISC and WIPO of KSCST, he follows up all the information, education and communication activities of PIC, including IP filling, that is patents, copyrights, trademark, design, and establishment of IP cell, institutional policy making, visitor consultations, and other projects and programming of the Patent Information Center. He is a coordinator of Technology Innovation Support Center, WIPO, of KSCST, and the coordinator of KIRAN IPR program of DST and TIFAC, where the program provides on-job training on IPR selected women candidates under the scheme at KSCST. Now I call upon Mr. Nagarjuna MG, and this session is yours, sir. This podium is yours.
Okay, thank you, sir. Thank you for the introduction. I think my audio is audible, right? You can hear me, right?
Yes, sir. You are audible, sir.
Okay, fine. Just place my PPT and go ahead with session. I think my screen is also visible, right, sir?
Yes, sir. It's visible. It's clear and visible.
Fine. Okay. At the outset, I thank for inviting us, KCST, to the program. Okay, and in the beginning, we heard that SPC has also filed a lot of patents, and I also see, I mean, some faculties of SPC is also been in touch with us, and we have seen their status and all saying that they had applied for patent, some design registration has granted like that. Okay, it's good that now the colleges have been looking at making a portfolio of intellectual property rights. Coming to this particular topic, that is industrial designs today, this is one of the important tool I can say for the faculty, especially with respect to mechanical or electronics or whoever it is basically, okay, or the basic sciences. Okay, so because we know that patents is little costly, okay, compared to any other intellectual property rights. Patents are little costly, okay, but however we can also create some more intellectual assets with a minimum availability of resources, so that it can also leads to some kind of commercial aspects. Okay, right. If you consider this industrial designs, for example, if you take in the particular picture, okay, what is your option? Okay, I cannot see the chat box. Okay, fine. I'll go with my presentation first. Later on, if any questions, I can take it up later. Okay, so generally we prefer both the discussion type like sessions, but okay. So however, so if I say in the current slides, what is your options to select? Okay, so maybe most of them chooses black or blue or red or whatever it is. Okay, so if I say what are the parameters for your selections, the first and foremost parameter you say that the engine speed, the capacity of the bike, okay, so the mileage, right? And at last, when you say all the technical parameters, finally you come and end up with which type of color bike should I select. Okay, either I should go my Vastu Prakara or something like that, okay, or any of our own choice. Okay, so the final option for you to select this particular bike, if I say the final is the color, right? Okay, so let us see some more similar kind of articles here. Okay, so you can see jewelries here, right? Okay, so I think it looks like all very beautiful jewelries, right? So if I say so if you want to pick something, right, see the choice of each and every individual is different, right? Because someone may choose the left or right one. Okay, but in parallel, okay, somebody can say, sir, I can buy all the three. Yeah, okay, so it can also be done, right? So these are some of the articles where you have some separate kind of selection criteria for this particular articles for jewelries, for example. Okay, so if you take other simple examples in the scenario of mobile phone itself, ranging from a small keypad phone to the current model digital phones like iPhone or whatever it is. Okay, and if you can just look at the normal fan and the current fans which having both light fan, okay, and even some kind of AI processed fans also probably are coming in the market, right? Okay, so these are some of the selections where we have been in touch with these particular articles in our day-to-day life, right? Yeah, and here also some of other designs. Okay, probably the below, if you take, I'm only talking on the particular shape, not on the content. Okay, yes. So if you take some of the examples, these are also we are in day-to-day basis, right? And other example, if you look at this particular slide, I think most not all of are very familiar to this particular articles, like in our school days, like javelin, cricket, ball, basket, all the things, right? All the articles in this slide, either the way we have been touched, or we have been practiced, or we have been used at some part of time, right? Okay, so if you consider all those things, right, in the previous slides, so all the articles or the things which we have seen are in touch with our day-to-day basis, right? Okay, so and furthermore important aspect, if we consider, see every most of the times whatever the materials that we use, right, so is some kind of intellectual property protected articles. Okay, maybe in the form of patents, designs, trademarks, or some kind of copyrights, we're not sure. Okay, but however we are in touch with that. Okay, so in this particular concept, the combination or the selection of article plays a major role, where there the design comes into picture. Okay, so if you take a general scenario of statistics, like what are the filings related to industrial designs in the current generation, see we have the innovation global innovation index and Indian innovation index rankings has been given yearly basis, right? Maybe in the world forum or with India also. Okay, so there some of the key factors to provide this ranking will be the number of intellectual property filed in the country. Okay, like maybe patents, trademarks, or designs, whatever it is. Okay, so apart others, maybe you can see human capital. Okay, the kind of knowledge, okay, knowledge diffusion, all those, these are some of the parameters. But here also IP plays an important role in putting an India in global map, right? And if you take as an example of a lot of companies, right, the Coca-Cola, Apple, Microsoft, all those companies, okay, right, they have a strong assets of IP portfolio. Maybe you can take, this is 2017's little older slide. Okay, so each company, for example, IBM, okay, it has about 8,000 to 9,000 patents filing per year, right? So probably the filings has been increased. Why? What is the reason that all the companies are interested in creating an IP portfolio, right? Okay, so if you take the recent global innovation index, India has also in the 40th rank, and we are glad that we had been moving ahead. Hopefully the rankings must be go slow, and to do this, the contribution of each and every individual, especially with respect to the faculty of the engineering colleges or the degree colleges or whatever the universities, okay, so their contribution must be high, so that the ranking will be pushed towards. Okay, so if you take a simple example, like about 1.2 million industrial design applications were filed worldwide in 2021. Okay, so probably you may guess that is China will be in the forefront, even if in the patents also China is in forefront. Okay, so India is also one of the leading country in the designs filing in the worldwide. If you can just look at it, this in graph. Okay, and if you take a simple scenario of what is the design filings in India in the recent 2021, about 22,000 design application has been filed, and we have also seen a lot of a lot of universities has filed more number of applications. Okay, so maybe I can see I can show some of the slides where people of different engineering faculty have been filed. You can just cross check for your reference. Okay, so about 22,000 applications we can see, right? And if you compare patents, it's about 66,000. Okay, now a simple example like how this designs works in our day-to-day life. For example, if you take, okay, okay, sir, I think I need the coordinator's help here. Okay, because there is one small questions here. See, I think you can see my slide, right? There is a kind of problem here. Okay, so this particularly a oil container, and there is some kind of disturbances over the place where the oil is kept, right? Okay, so can you just tell me what was this problem, and what may be the solutions for this particular problem? I need the coordinators to kindly help me by reading their chat answers. Any answers? Like, what was the problem here? Do you find any problem here?
Participants
Okay.
can unmute and discuss.
Yes, yes, sure. They can discuss. Yes, yes.
Anybody?
What was the problem here, basically? I think this is very common in all our kitchens, right?
The oil we are using, whenever we are using it, it may leak. Like the first
Yes,
bottle
madam.
shape is good enough to pour the oil, but whereas the
Yes,
second
madam.
bottle shape is not good enough. So
Okay.
yeah.
Fine, madam. Madam, now what is the probably solution? What may be the solutions for this kind of problem? Because generally, if you consider this problem in homes, at least 15 days once or 1 month once, we need to clean the vessel with the help of hot water or cold water. Okay.
Yes.
Yeah. Now, what is the alternate solutions you can think of for this?
So cleaning the bottle is one side, sir. Like and shape of
That
the
is
bottle.
traditional.
Yeah. Shape
Yeah,
of the
that is traditional method is correct. The
yeah.
other probable solutions, what you are saying is the shape of the bottle. If you change the shape of the bottle, maybe some kind of the contamination will be reduced.
It will reduce the
Right?
leakage of the yeah.
Yes, exactly, madam. Exactly. I think probably with respect to your answers, we can see a lot of these kind of shapes. I mean, the bottles in the market, right? Okay,
Yes.
some kind of yeah. So most of them are because of these issues, we have been inventing this thing in a different way. Okay, so even if you take these kind of bottles also, okay, so the contamination is continuous, and maybe it can be seen in our day to day, right? Yeah.
Yes.
Okay. Uh, can you recently in the market, can you find out any one similar kind of shape of bottle or any oil company where this kind of problem will be eliminated? Or maybe, for example, in the normal days, at least 15 days will be for the problem. Okay, if you use this bottle, the kind of the problem, I mean, maybe it can be extended the life, maybe 1 month or 1.5 months, you can see this kind of situation. Have you seen, madam, any similar kind of?
I think I might have not remembered, but the handle, no, sir. That kind of these things have come, no, sir. Like
Yes.
in the petrol bunk and all, when we go, like the
Yeah.
to put oil for an engine and all, along with the bottle, there is an handle.
Yes, exactly.
Not
Okay.
this kind of handle where you're sure you're pink, I mean, red lid
Okay.
and black, I mean, blue lid. That kind of
Yeah,
handles
even
also.
this red, even this red lid and the blue lid also have the same issue, madam. Okay, even the silver is also had similar kind of issue. Okay, I think we have seen this, right? We have seen this kind of bottle, right?
I was about to say
Yeah.
this part.
Yeah. Okay, so this is a freedom bottle. Okay, if you just look at the topmost, I think someone is unmuting. I request. Okay, fine. It's clear now. Okay, I think we have been used this freedom bottle. Okay, so if you
Yes.
consider this the topmost criteria, okay, with this particular design or with this particular shape, the leakage of oil from the bottle is too minimum. Okay, because there is a separate line where even if it is because of the density difference it comes out, okay, again it fall back to the container. There is a system that they have been introduced. Okay, so this is one of the best example I saw in the market right now, okay, which can solve this issue. At least I've also been using this bottle at least minimum 2 months has happened, but I have not seen any kind of that much compared to the earlier, okay, the problem. Okay, so these kind of small innovations, maybe we can say this. Okay, so I just thought of whether any kind of IP is protected with respect to this kind of shapes. Okay, if you just take in the design registration, okay, so this company's bottle shape is protected. Okay, so I'm not sure about the like the projections, like whether it is protected or not. Okay, but if you take the container as it is, the complete container is registered with the help of design registration. The company is Gemini Edible Oils and Fats. Okay, yeah, this solves the most of the problem, I believe. Okay, so even if you take the companies, okay, so there had been other similar kind of bottles have also been registered with respect to that. Okay, yeah, so the basic idea behind this is that everything is designed. Okay, we have seen a lot of designs, okay, but few things are designed well so that it can have the market existence for a longer period. Okay, so if you take the basic identification or definition of industrial designs, like how the designs works. A design is basically a shape, configuration, pattern or ornamentation, composition of lines applied to an article in maybe industrial or automation form. Okay, so where the design is aesthetically appeal to the eye and article is solely judged by the eye, and the protection is given for appearance of the article only. Okay, so basically whatever you see in the market, okay, the shape, configuration, pattern, ornamentation, composition of anything, okay, so these kind of articles comes under industrial designs, and these designs, the protection is given only for the its aesthetic appeal. Okay, yeah, so I think we have seen a simple example. If you can consider, okay, the shape, the pattern, the configuration, okay, so ornamentation, all the things we have already seen this. Okay, the in our earlier slide we have seen. Okay, so if you take this cup for example, okay, the configuration of the cup here. Okay, so we have saw in the market a saucer, a cup and spoon. Three are there. Okay, but here one fellow has just did a hole on the handle of the glass and he inserted the spoon, and this makes some kind of a new design, and this is registered. Okay, so I have not seen this kind of article in the market now, but however, this is a registered protected design, and shortly it will be in the market. Okay, it is filed by some Maharashtrian individual. Okay, so these are the different varieties in the industrial designs where the articles have been classified and protected with respect to the industrial designs, right? Okay, so basically if you take the advantages of making an industrial designs, basically it helps to protect for appealing, and it make a unique selling point. Okay, for example, if you take a watches itself, so different age group people requires different kind of watches. For example, the kids, they may have a different taste of liking some kind of toy watches, right? Okay, the professionals, as we wear generally chain those kind of watches, and if you take consider the sports persons, they wear generally the digital watches, right? And if you can see a lot of people having the digital watches now. Okay, the fast tracks, what we call Bluetooth watches or something like that. Okay, so like this, the industrial designs targets a specific market segments, and they help in creating a new brands. Okay, so and so that the protection parallelly the sale of the any kind of brands will be for last longer. Okay, so the monopoly, if you take industrial design, can be for 10 years, and maybe it can be extended for 5 more years. Okay, so if you take the other parameters, for example, okay, the industrial design is also one of the intellectual property, right, where it can also yields good economy or royalty with respect consider in terms of patents also. Okay, so maybe little maybe something little. Okay, but however the it will be in the range of the same similar kind. Okay, so and obviously it grab the attention of buyers. Okay, it enhance the marketing strategy, and it add a commercial value to the product. Okay, and overall it is an asset to us so that we can sell, lease, license, or do whatever we want. For example, if you take a Coca-Cola bottle, for example, if you take in 1899, how the bottle looks, it looks like a poison bottle, right, in the lab. Okay, so later on with the innovation and the improvement over the existing product, if you can see in 1957, the final the bottle which we have seen now, okay, the Coca-Cola bottle. Okay, so the design is something different. Okay, if you just look at the bottle itself, you can say, yeah, this is belongs to the Coca-Cola. Okay, right. See, that's how the design is also plays an important role in reputing a brand and identification of any product with respect to any kind of brands. Right, and there are some of the parameters to be considered to do an industrial designs. A design should be not disclosed to the public. I think probably the other speaker will give brief about what are the conditions of this patentability. The same thing will be applicable to the designs also, where it should not disclose to the public. It should be significantly distinguishable from the known designs. Okay, so for example, if you take the glasses here, okay, so there are two glasses here, one with a conical shape and other with respect to some kind of circle, right? But you can differentiate two glasses even though they are made with the same material, right? See, that's how our article should be significantly distinguishable from each other. Okay, it should not contain any scandalous or obscenity matter. Okay, for example, you cannot create an article with where it is used in bathrooms, some kind of god photo or such thing like that. Okay, and and it should not appeal to the article and should apply to the eye, appeal to the eye. Sorry. Okay, and it should not be contradictory to any public order or morality. Okay, with respect to any kind of religious matters. Okay, so that kind of designs cannot be accepted. Okay, maybe if you can see, you cannot rename that the old Kram as Baba Ramdev Ram. Okay, so it is not acceptable, right? Because it's all famous and there in the market for so longer period. Okay, yeah. And there are some other parameter in the designs, okay, industrial designs if we consider. The principle of construction, mere mechanical devices, buildings and structures, and the trademarks and the copyright works, okay, the copyrighted articles, right? So these are the important other areas where the design is not given for registration. Okay, so basically the mere mechanical devices, for example, if you take the kitchen articles which we use on our day-to-day level, the knife, all those things and all, see the basic things. Okay, so those cannot come under industrial designs. Okay, and we follow, I think you might have known this, that we follow Design Act 2000, and where it have about 11 chapters, 4 schedules and 48 sections. The first schedule deals with the phases, the second schedule deals with the forms. There are about 123 forms. Okay, so depend upon the requirement we need to file, basically form 1 for application, form 2 some other parameters. Okay, so they're all there. And third schedule deals with the classification of goods, we can also see that. Okay, and fourth schedule deals with the differences or the cost involved during the proceedings in respect of registration. Okay, and we have also, you might have known that Kolkata is the head office for designs, and however we can file the design application with respect to the jurisdictions. For example, our applications, especially with respect to Bangalore or southern country, need to file in the Chennai patent office. Okay, yeah. So who can file? If you consider, anybody can file, any proprietor of design can file. Okay, so any college or partnership, private legal entity can file this design application. Okay, and this is the classification of designs. If you consider, there are about 32 classifications, and class 1 deals with foodstuffs. And if you take as a faculty, there are a lot of opportunities for us with respect to these classifications. For example, if you take class 24, mechanical and laboratory equipments, because we are dealing with a lot of especially if you take chemistry and biotechnology and biochemistry people. Okay, so they do a lot of research oriented activities, right? So in this direction they can come up with their own kind of building molds or blocks. Okay, so some kind of apparatus to test the standard quality of chemicals or whatever it is. Okay, for example, if you take 23, fluid distribution equipment, sanitary, heating, ventilation, air condition equipment and solid fuels. Okay, so this is one more branch, I mean classification, where we have a lot of opportunity to design. Okay, 21, games, toys, 10, sports goods. Okay, and other classes, if you take class 7 and class 1, that is household goods and foodstuffs. So these are some of the classes where we can think of creating our own designs, right? Yeah. And before file any industrial design, we need to do the search, like either whether the design is already existed in the market or similar kind of designs are available in the market or not. So we need to do that. Basically, we can say that prior art search of design articles or design registration. Okay, so in similar way of patents, like how we do the patent literature survey or patent search with respect to the free and paid databases, in designs also we do the same thing, and we have Indian database and parallelly WIPO database also. Okay, so maybe you can cross check with these two databases is more than enough to file, judge and to file the design applications for us. Okay, so this is the global database, and now in WIPO itself we can access the Indian database also. Okay, so because in Indian database it's little tough to search. Okay, we need to go by with classification or name or company's name. Okay, but yeah, so but in the WIPO maybe you can we can have the multiple designs across, and comparatively the WIPO design database is quite easier as to search. Okay, there are some examples to be showcased to you. You can just look at it. Okay, so here the drone has been registered. Okay, see the main the point of reference here is we have seen a lot of drones like octagonal structures, hexagonal structure, right? But compared to the other structures, here the drone is little different compared to the previous which the standard drones, right? Okay, so these if the product is very unique and the appeal is somewhat different, right, then immediately you can file the design application. Okay, so this is one of the those things. I think most of them will have habit of taking tea biscuits in the morning time, right? Yeah, and if you consider the shape of the biscuits, like each company shapes are different because all the shapes patterns have been protected under industrial designs. Okay, if you take Britannia, Britannia and other crack jug or whatever the biscuit packets in the market now, okay, you cannot find a similar kind of designs with respect to the same different companies, right? See, that's how the designs plays an important role. And if you just take an example of Good Day biscuit packet itself, just 3 years back or 4 years back, how the biscuit shape looks, and even the patterns are same. Okay, but the appearance of patterns for each year they're changing. Okay, now they changed the logo as Mom's Magic. Okay, so some kind of a laughing symbol with respect to the pattern on the shape. Okay, so like this, there will be an evolution or the advancement with respect to the designs. Innovation has to be there so that they can maintain a long strategy of selling their brands in a good way. Okay, yeah, and if you take the masks, right? Even if you take the simple mask now, 10 rupees. Earlier it was only 1 or 2 rupees before COVID. So after COVID came, so the price increased tremendously. Okay, and a lot of like khadi masks have come. Okay, so some advanced updated masks have come. We have seen this cloth masks, we have seen khadi masks, we have seen this medical mask, we have seen N95 mask, we have seen. Okay, now what is the next step in this, or what is the next phase of this? Okay, so somebody from where Punjab, okay, so they designed and developed a mask with earphones. Okay, so this is the innovations happening in the existing place where to gain some kind of market advantage. Okay, yeah, this is one of the recent masks which has been, this is filed in 2021. Okay, yeah. Now we have also seen this, right? The art of jalebi making is very difficult. Generally, in even in homes also, we never do this jalebi making process because the preparation is required somewhat to experience, and also it needs skills to put exactly the shape of this particular jalebis, right? Okay, so here we have one parameter, that is one fellow has developed a jalebi maker where you can just you can go across with the pattern. Okay, so automatically the jalebi shapes will come. Okay, yeah, this is how the innovations happening here, and this is filed in 2022. The last year they had filed the registration. Okay, yeah. I think in the beginning I have shown a slide where we have been in touch with the sports goods, right? Even the sports goods also is protected either some kind of IP, that is one product is that designs. For example, Nivea, we have already seen, we have played many times the basketball. Okay, so this is a registered design which we are practicing. Okay, so the shuttlecock, if you see the pattern, this is also protected. And the pharmaceuticals tablets, if you take normally how the tablet shapes was like, it was generally round or a capsule type. Okay, so recently these are some of the recent designs which has been including in the patterns also. Okay, like if you take chocolates, there are different kind of chocolate patterns, right? So in similar way, even the pharmaceuticals also trying to implement the tablets in that shape so that they can it's some kind of innovative way to sell your goods. That's all. Okay. Now, if you consider the complete filing process, okay, so basically you need to just come out with the design first, like the appearance or the article what you want to think of. Okay, so later on, once you had done with this particular article, then you need to go with the a basic literature survey. For example, how the design search with respect to the WIPO or whatever it is. Okay, so then you know that the design which you are come up with is some kind of unique and it has some kind of attractive place in the market, then automatically you need to prepare your application. So then you should submit your application in the patent, that is Chennai Patent Office. So automatically the examination will take place. Okay, so then if any kind of issues with respect to the granting, for example, for example, if it falls under any criteria of trademark, copyright, or the parameters which I have said in the earlier. Okay, so then it will examine accordingly. The formality check will be happen. So it will be checked according to the rules and regulations. Okay, so later on you will get a notice that you need to differentiate, or this is not a novel design. Any objections may come. Okay, so that objections we need to defend, and the objections has been met with clearance, then automatically the registration will be given to you. Or if it is opposed, then proceedings will take place. Okay, so we need to go ahead with the proceedings, and we need to defend our article or the design, and then we need to get the registration. Okay, so and there may be a chance that maybe it is accepted or rejected also. Okay, yeah. And if you take the cost required or the forms generally used in the design applications, if you see, so basically the registration form 1, maybe if once you file within 6 months, probably you can get an industrial design. Okay, so if you have an extension of fees, form 18 should be filed. This must be 3 months. Okay, any kind of reply within 6 months, you need to give the reply. Okay, then generally they mention the dates with respect to that. You need to follow up with the application and you need to finish the task. Okay, so any restoration or cancellation, you can do it anytime. Okay, so most probably the how the patents scenario is there, for example, filing, prosecution. Okay, so similar articulation will be there for designs also, right? And this is a simple model how you need to prepare your application. Okay, for example, if you have a shape of a bottle or a shape of an article, okay, it has to be represented in a representation sheet, basically in A4 sheet like this. Okay, so the left corner you need to include your name, the right corner sides you need to paste different orientations. For example, front view, rear view, back view, side view, or 4 to 5 views you need to paste in a separate sheet, and you need to mention the where the novelty resides. For example, if you consider this teapot, the novelty resides in the shape of the teapot. Okay, so these kind of the novelty statements has to be given, and later on you need to put your signature, and along with the form 1 application you need to submit to the Indian Patent Office. Okay, so the basic requirement is form 1, that is the application, and form 21, power of authority or general power of attorney. Maybe if you are going with any kind of agent or attorney, you need to submit this. Okay, and since you are the college, okay, so you need to submit the form 24, small entity or startup form. Okay, so any assignment documents, basically if you are doing any kind of business with respect to this, okay, so you need to follow the documents and you need to submit it. That's all. Okay, so this is the basic understanding, like how you need to prepare the application. Okay, and this is how the registration will come to you. Okay, the cost required for filing a design registration is about 1,000 rupees, and for companies it is about 4,000 rupees. Okay, so maybe generally the cost varies in designs. It starts from 200 to 4,000 or 5,000 rupees. Within that, there will be for different stages. Okay, and basically, if you want to get a registration, 1,000 to 2,000 you need to spend, and you can get the registration. Okay, and this is one of the design applications. This is called as pomegranate promo peeler. Okay, recently we have done this, and it is got granted also. Okay, so here the inventor, the proprietor, made a pomegranate promo peeler. Okay, so the model is he is in the process of preparing that model. Okay, a prototype. and shortly it will also be in the market shortly, I believe, right? Yeah, an example. Okay, and now here, like for example, if somebody copies our design or something went wrong, then what is the remedies we have? Okay, like however in the patents, the similar kind of infringement suits here also will happen. Like if somebody copies, you can sue them and you can claim the damages also. Let us deal with some of the one or two case studies. Okay, then we can conclude the session. Okay, yeah, if you consider this, that is here we have two industries taking together. Okay, so one with respect to RCI, this is basically an Harpic design bottle cap. This is okay. So this RCI filed case against RIL saying that they have copied their bottle design cap and they are doing the business. Okay, so as it is, if you think like if you compare both the bottles, okay, so it looks like that the copies happened and we may feel that this is infringement. Okay, but however the court has observed with respect to comparing these two companies, okay, the defendant, that is RIL, this the court said that, see, basically the design, the shape of the cap, okay, the inclination angle given for this particular cap is about 45 degrees basically, and if you throw any article in the 45-degree angle, right, the projectile motion will be very longer, right? Okay, and so in this consideration, to increase the velocity of liquid, the inclination angle will be given, and that's why the shape appears like this. Okay, so based upon this criteria, the court observed that this is completely a functional aspect, and hence no infringement happened here, and anybody can do they can incline the shape and they can do the designs. Okay, so this is how the context here is that design is given only for the appearance of the article, not on the functional aspect. Okay, and indirectly, if you say anything, if you want to do design, the basic criteria will be the functional aspect. For example, if you take automobile vehicle, okay, to reduce the vehicle, what we need to do, we need to redesign the shape, or we need to reduce the material, or we need to come up with some kind of fabrication or some kind of material so that it can reduce the weight, right? Okay, the major objective of us is with respect to the functional. Okay, but however, design is given only for the appearance of the article irrespective of the functional aspect. Okay, yes. Now come to the one more example here, like the footsteps. A lot of design art, I mean design patterns have been in the footsteps. For example, if you take Balaji and Roombas, these are the two chips in the market. Okay, so Lace we already known because this is the biggest company, and they have a good market all over the world, right? And Balaji is an Indian company. Now Lace filed a case against Balaji saying that they have infringed the pattern of the chips, and the company has doing the business. Okay, with this, the Lace infringement case, okay, the court immediately observed and said that to stop the Balaji affairs. Okay, so as it is, if you look, right, maybe the shapes, it looks similar. Okay, but the court observed that the intentional copy of the Lace chips, and hence Balaji has given interim injection now, and still the case is going on. Okay, but I don't know how Balaji has to define this case. I mean, because they have an option to disprove that this is functional design. Okay, so that's one of the options they have to disprove. But let us see what it happens. Okay, but right now the pattern which considered to the both, and Lace has upper hand now. They have stopped Balaji with stopping the production. Okay, so this is one of the other case with respect to designs. Yeah. Okay, I think we have been seen this Haberman company. Okay, so this is very famous with respect to the design of especially baby utensils. Okay, so the shapes. Okay, so the basic idea here is that, okay, so they have a wonderful portfolio of patents and industrial designs as well. Okay, so the one of the best saying of him is that the designs or the IP portfolio has protected them with a lot of what I can say that the portfolio has increased, and the company's revenue has been increased due to this protection of intellectual property rights. Okay, so these are some of the basic ideology about the industrial designs which I have shown. Okay, since it's an online mode, okay, so a lot of discussions is difficult for us to make. But however, I tried to convey in a simple way that what are the different aspects of industrial designs, like the patterns, ornamentation, shape. Okay, and as a faculty, we do a lot of research with respect to, take mechanical engineering itself or electronics or civil engineering. Okay, so all the areas. And apart from that, we need to think behind the subject matters also. For example, we need to inculcate this intellectual property with our day-to-day basis, right? Okay, so if you found any problem, right, so there you need to come up with some kind of solutions, and we need to find out which kind of possible solutions for this particular problem, and in what category it can be satisfied with respect to the intellectual property rights. Okay, so maybe patents or designs or whatever it is. Okay, so then parallelly you need to develop those kind of designs or patents or whatever it is. Okay, so then if you go ahead with protection, probably the chances of that particular product coming up to the market and making it as commercialization product will be more easier. Okay, compared to the rather our traditional research what we are doing it. Okay, so this is what my a small presentation with respect to industrial designs. If at all, if you have any queries, it's open for questions now. Yes.
Session, sir. I have small doubt.
Yes, madam. Tell me, madam.
Sir, like designing and patterns and all, okay, I accept it. But sir, like,
Yeah.
do we have? See, if if I am not having any manufacturing unit with respect to a
Yeah.
design or a pattern, so can I just
Yeah.
sketch the design and then can I go for the registration?
Yeah, madam, absolutely you can go. Okay, so there is no need for manufacturing itself. Okay, but however, making manufacturing product is a mandate. Like we need to do it. Okay, but in the
Okay.
initial stage, to get a registration, you can say just sketch the drawing, and you can just go ahead with the registration. Yeah, possibility is there. For example, if yeah,
Fine. Sir.
yes,
Tell me,
yes.
sir. Continue.
Yeah, you have seen that model, right? That is pomegranate promo peeler. Okay,
Yes.
basically he's also a mechanical engineer, and he just designed that. That's all. He has some shapes. There is no actual prototype for that. Okay, now he is making a prototype. Okay, so likewise we have the option, and we can just do it. Yes.
Thank you. Thanks a lot.
Yes, madam.
Good morning. Good
Yeah, madam.
morning,
Tell me,
everyone.
Yes, sir.
Can I speak, sir?
Yeah,
Yeah, madam. Please go ahead.
Hello. Hello.
Yeah, hello, ma'am.
Sir, from
Please
here,
go
from
ahead.
College of Engineering, sir. Sir, actually, I just had a doubt. Like when you were with the tablets and the chocolate designing, like when we are designing with the chocolate or the medicines, like the tablets, like be the design of the chocolate to the medicines where the people can't discriminate with the design parameters, sir.
Madam, can you come again? It was little disturbance. I couldn't able to hear properly. Yeah.
One particular example, sir, we have certain tablets which is similar to a jump that we are
Yes.
available in the market, the chocolates. It is similar. The
Yes.
tablets is also similar design where the people can't discriminate whether it is a chocolate or a medicine.
Yeah. Okay. I think most of the times people are aware that what is tablet and what is the chocolates. Okay, because the best identification is the wrapper. For gems, we have separate wrapper, and even the same kind of shape with respect to the medicine also, they have some other kind of wrappers, madam. Okay, maybe we can easily identify. I think so. I'm not sure this will become a problem, I believe.
Sir, but when we go with this two particular things, two particular things. If it is taken by a small child, like if we have
Okay.
removed and it's taken by a small child, is there anything like whenever we go for the designing aspects, is there any discrimination we need to make? Like if it is a food product, it's an eatable one, or it is a medicine,
Okay.
we have to go with the design parameters. Like, is there any parameter that
Yeah,
we need to
madam.
concern to have the discrimination, sir, with the sectors?
Yeah, madam. See, basically, the design, the classifications which we have shown, right? There are 32 classification. Okay, so you need to file on with respect to that classification only. Okay, for example, foodstuffs, class 1 deals with foodstuffs. So when you are filing with respect to a chocolate, you need to file with respect to the foodstuffs. Okay, and another classification I just told, that is 23, some kind of medical equipments. It comes like that. Okay, so there you need to just give the classification and you need to file the application. Okay, then automatically I mean, most of the times the controller also decides, okay, under what classifications your application has to be registered. Okay, if you are in some country, they can take a call, madam. Yeah.
Okay, thank you, sir.
Okay, yes, madam.
Good morning, Nagarjuna sir. This is Dr.
Yes.
From Energy Institute, Bangalore. So
yes, sir.
that was a very, means I should say, informative presentation from your side. I
Yes,
would like to know how long it takes for total total time it takes for the patent to be granted. What's the normal time?
Yes. See, for designs, maybe within 6 months you can get a design. Okay, at least that is minimum 6 months is required generally, if I say. Okay, and 6 to 1 year or 2 years you can get a design. Okay, in similar way, patents also minimum 6 months is the time. Okay, and maximum it go up to 2 years, 3 years, 5 years. It depends upon the examination procedure. Okay, but minimum 6 months is the waiting period for patents. Okay, but designs you can get within 6 months.
And we need to have this one get it fabricated once.
No, not required. It's not mandate. It's not mandate. Okay, but the objective of protecting design is to create some kind of business. For example, industry people, if you take, okay, each shape or each a parameter that they vary, they immediately do the registration because it is already in the market. Okay, they have the advantage. But as a faculty, this is one constraint for us. It's not a mandate for us, sir.
Okay, sir. Thank you. Thank you for the information, sir.
Thank you.
Yeah,
Yes,
I have some more queries. I will connect you through mail.
Sure, definitely. You can call us also, no issues. Yes.
Okay, thank you very much.
Yeah. Okay.
Any more questions from participants? Anybody else wants to discuss?
If there is no question, then we move ahead to the second session.
Yeah. Okay, sir. Thank you. Thank you for inviting us. Okay, if you have any queries, you can approach us at any time with mail or with our contact details. Okay. Yeah.
Thank you, sir. Thank you, Nagarjuna sir, for your wonderful session. And now our second session speaker is Mr. Janateja Bandi. Mr. Janateja Bandi, presently he is a research assistant at a DPIIT chair on IPR at National Law School of India, University Bangalore, and IPR consultant. Mr. Janateja is a law graduate from IIT Kharagpur, specialized in intellectual property rights. He is also a qualified patent agent of India and served as a startup facilitator for filing patents and design under SIPP scheme. A tech lawyer having hands-on experience in patent prosecutions, he drafted and helped filing patents and designs for various tech domains like pharma, biotech, mechanical, electrical, biomedical, etc. He is also involved in trademarks, copyrights, prosecutions, having extensive experience in production and promotion of geographical indications in India. He works closely with various startups, incubators, and advise them in various tech legal issues associated in filing of Shauri painting, first GI from the state of Jharkhand. He also working for the authorized user of registration for geographical indicators like Bobili Veena, Machilipatnam, Kalmari, Gulbarga, Tuvardal, etc. He is actively contributes to the area research in geographical indicators, IP and food security, trade secrets, promotions in India, medicines and IP, access to benefit sharing. As a part of awareness initiative, he is actively participated in resource person for various educational institution, startup meets, also organized various roundtables on IPR in association with NLSIU, IPO, and WIPO. And I welcome Janadeja sir for this session. Janadeja sir, this session is yours. Podium is open, sir.
Thank you. Thank you,
Oh,
Mr.
sorry to
Sridhar.
interrupt. I want to add one more point here. Gnanateja sir, special thanks to you because you were very much keen guiding us. Last week, because of you, we could get a patent which was related to my PhD thesis, which was done in our lab. Yeah, thanks to all your efforts because we were not aware that it can go up to that extent. Only because of your guidance and motivation we could do it. So thank you, sir. Thank you very much.
Thank you, sir. Anytime for SVC. So thank you so much, sir, Mr. Sridhar sir, for your kind introduction, and also Sunit sir and Nageswar Rao sir also. Kindly please let me know once you see my presentation slides. So today there is an interesting topic that we are going to discuss on innovations and patent. So generally, so at any point of time, you can unmute yourself and you can raise your questions. So I will be very happy to answer those questions at any point of time. Generally, like when we go for these talks, generally it will be that the titles may be like, introduction to the patent systems, or else, patent filings, or else on overview of the intellectual property rights, academics and IP, etc. But when Sunil sir and also the organizing committee said that, the topic for today's discussion is on innovations and patent. So this is something interesting that we need to discuss, where there are a lot of, confusions with related to patentable subject matter, or else, what all the inventions or innovations that can take care till the patent systems. Okay, how we can file it, and what exactly the difference between innovations and also the term invention. So before going into this topic, can someone, unmute themselves and answer what do you understand by the term innovations and also the inventions? Is there any difference between those two, or else both are like, interchangeably using?
Innovation is a new idea.
Sorry?
It's a new idea.
A new idea is an innovation.
Yes.
Okay. Invention? So can you please confirm once you see the slide? So anyone can try to, I mean, like, as per your understandings, what is an invention means? Or
Sir,
else
I would
innovation?
like this, which is already existed. On that, again, any new ideas come up, it is called innovation or invention. I don't know, but one is the originally what we start is going to be the new one.
Okay. So
Yeah.
one is originally what we are going to start is new one.
Yeah.
Other is like, it is already there and then we are keep on working on new developments, etc.
Yeah.
Yes. So this is, sorry, actually there is some issue with my slide sharing. Give me a minute, please.
Okay.
Yes, can someone please confirm whether you can see this slide?
Yes, sir. Your slide is visible.
Thank you.
Yes,
Thank
it's
you.
visible.
Yes. So yeah, today we are discussing on the innovation and patenting. So we are not going in detail, of various patent aspects, but the basic concepts on the patenting and also the innovations and inventions revolving around the patent systems. That's what we are going to discuss, and this is very important to us as an academicians and also as a budding innovators or inventors. So we need to know what exactly can be the patentable subject matter, or what exactly is an innovation or invention it is, and whether all new elements or else inventions can be qualified as a patenting system, or else whether they can come under various intellectual property rights, like the designs that what we have discussed in previous session, or else maybe the trademarks, or else the copyrights, etc. Right? So as rightly pointed out by from the audience, that what innovations are mainly for the there is the technology is already existed, or else the knowledge is already existed, the product is already existed, but there is some new developments keep on going on that, right? We are creating something new on the existing things. So that innovative ideas, whether it can be protected or not, is what we are going to look. Next one is inventions. So inventions are completely new. So it can be a blockbuster medical product, drug, or else a mobile phone, or else any sort of technical related aspects or inventions that are invented for the first time, which are the technical skills of a person who is in that particular art. Right now, can we protect these innovations? Because our topic is related to the innovations, and innovations, as per our understanding, is that the invention is already there and then we are creating something new, or else we are developing or we are innovating some new solutions to the problems which are already existed, right? Can we protect that innovations? Also, whether the Patent Act is talking about innovations, or else whether it is only confined with the term inventions or not. So this also we are going to look. Now coming to this slide, now you can see this slide, right? So there is a lot of evolution happened with related to this one particular technology, or else with one particular product, with this cellular phone or else a mobile phones. So from starting with which it takes, there is even no camera as well, actually no inbuilt camera as well in the initial stage, only it is used for the communicating, that's it, right? And now at present stage we can see that okay, we can operate with just with one finger touch, and then we can operate, and then we can even take the pictures, or else we can communicate with the persons in a way of video calls, etc. And also you can attend the meetings as well with related to that one small device, that is a mobile phone, right? So these are the innovations that are happened with related to one particular invention, where there is a drastic improvements and changes coming up. And also it may not end till here, we may see, or else we may
Sir, excuse
Yes, sir.
me for interrupting. You put it in a presentation mode, sir, because your slides are not moving.
This is in the presentation mode only, sir, actually. So can you now? On my screen, it is completely in the presentation mode.
No, sir, here it's not coming in presentation mode. We can see the layout.
Okay, give me a minute, then I will share again. Just So now can you see, sir, the slide?
Yeah, I can see the slide, sir.
Okay. So can you see this now, the slide moving?
No, sir, slide is not moving, but I can see what the slide you put, that mobile slide,
Okay.
that is visible. Sir.
The
And
next
again,
slide.
I can see other your layouts.
My layout. Okay. No, from my end, I can see only full screen because I clicked the presentation mode only.
It's okay, sir. You can share it. We can.
Now this is not in presentation mode actually. So now there are slides on this one. Now again, I'm clicking on the slideshow. So please, Abhi, can you see, sir, now?
Sir, your slides are visible. There won't be any issue with that.
Okay.
But it's not going to that presentation mode.
Okay, but here it is in presentation mode. Maybe there is some
Okay,
technical
sir.
glitch. Yeah.
Okay.
Sorry for that. Yeah. Yes. So we are with related to the mobile technologies. So these are the innovations that are happening, keep on happening, and also in coming days or coming years, we can see even more innovation or innovation ideas that can be keep on working on these existing technologies, right? So now the Patent Act, whether the Patent Act only talks about the inventions that are created can be protected, or else whether is it talking about the innovations or not. Okay. So even with one more example that I would like to bring in here is that the zipper. So this is a patentable a patent. There is a patent on this particular technology, that zipper, but there are again a few innovations happened before creating this zipper. Mainly the first blockbuster thing what happened is like with related to the sieving machine, so which is used actually to sieve, or else to combine both the clothes, or to with related to with the by using with the sieving machine actually, right? So this actually created or else it throws some light on the creation of zipper into a patent zipper. So next, after 40 years almost, there is again the technology innovations are happening. Okay, the scientists keep on working on that, and there is one more zippers for a locker which is related like with the zipper only. So which is used only for the for the shoe actually. So this is known as a clasp locker. So which after the sieving machine, after 40 years of invention of sieving machine, this came into picture, and there is a patent on that as well. So that is also protected. Now even again the still on innovations are keep on happening, and then there is a blockbuster invention came into picture. So this is an actual zipper which now currently which we are which is in the market in use instead of the buttons. We can use this zipper as well in many of the fashion industry, in most of the fashion industries, right? So this is called as an separable fastener. So this got patent in year 1917, and also this separable fastener is used with the US Army with as a zipper, and then this became very blockbuster and commercially success. Actually, to bring this zipper into market, or else to this zipper as a patentable subject matter, there are already inventions which are there in the market, but this is a mere innovation which happened with the already existed technology or already existed knowledge in the market, right? So from the threads, or else from the dots that are there from the sieving machine and also from the locker, so there is the scientist observed that there is still more need for the inventing, or else to bringing up something called as an separable fastener, which can be used beyond like an shoe locker, or else or else just an sieving machine to to combine two cloth pieces, etc. But it can be used as an alternative as a buttons in the fashion industry. So this is a patent, and then this patent.
Gnanateja, sir?
Yes, sir.
Sorry to interrupt you. Your slides are not moving, sir. It is stuck up with that mobile phone slide.
One second, sir. So I'm trying here, but still.
It's in slide number 3 only. It's in slide number 4 now.
In slide number 4, now I clicked here because I came back actually. Initially, it is in the slideshow only.
Okay. Okay, sir. Please continue. Please.
Okay, then what I'll do is like I'll keep clicking on the slides like this. Is it fine?
Yes, sir. Yes, sir.
Yeah, I think there is some issue. Okay, so this is what I'm talking about, the the zipper, the separable fastener, and as well as the how the separable fastener came into existence from the sieving machine invention actually. So this is what an invention that is patented in 1851. So from that inventions, there are a series of innovations happened to bring that zipper into the market as a separable fastener. So the patent on that zipper, the title is the separable fastener, which is patented in the year 1917. And then this is what we are still using actually in the fashion industries, etc. So now coming into the terms, inventions and innovations, and also whether the Patent Act, in India, actually, we had the Patent Act, the Patents Act 1970. So which deals with the definitions of patent, okay, what is the eligible criteria for the patent and how you can file and where you can file the patent applications, what are the requirements for the patent applications, what are different fees that you need to pay to the patent, when you are protecting your patented inventions, and what are the different forms that are required, what is patent infringement, or else what are the patent oppositions, how long patent can be protected, so how you can license your patent, or else how government or else any person can apply for compulsory licensing, etc. So these all are dealt with Indian Patent Act, okay, the Patents Act 1970. So when you look into the Patents Act and when you search for the terms innovations and inventions, so there is only one reference to the innovation in one of the sections in 94 or 92. So it states that the patents are used for promotion of technical innovations, right? So the one of the main objectives of the patents is that it should promote the technical innovations. It means that the granting of the patent should also contribute not only for the commercial success of the inventors or else the persons who filed it or who have secured the patent on that, but also it should promote the technical innovations. So when the patent is available in the market, so when the patent is published or else it is already granted or it is already published, so it is accessible to each and everyone. So anyone can view that patent application and anyone can download that patent application. Anyone can read that patent application. So by looking or reading that patent application as a person, you are skilled in that particular art. So you may come up with some problems or, you may find out there is something need for still betterment of that existed patented technology, right? For example, there will be, there is a patent, so which is talking about, a medical product, which is treating the body temperature, so antipyretics, so which reduces the body temperature, or else in a normal language, if you use it is to reduce the fever. So there is already a patent on that particular application. So now when you read that patent application, then as a scientist or else as a pharmaceutical researcher, you came to know that by taking that medicine, so it takes almost 10 hours to show its effect and then to reduce the body temperature. So now you think that there is a need for better innovations or better improvement of that existing technology, where you can come up with an invention which states that your patent applications of the product reduces the body temperature by 4 hours, right? So hence the existed patent application is already promoting the technical innovation. So it is throwing some challenges to the inventors or else the scientists or researchers to keep on working on the existing technologies. In such a way, it is promoting the technical innovations. So this is the only one section where you can see the term innovations under the Patent Act, but it's in everywhere you can, there is a reference to the term only inventions. So it talks about almost like, more than 200 plus times the term inventions are used in the Patent Act mainly. So where the inventions, it clearly defined that what are inventions and what are new inventions, and also it defined about what are not inventions. So this is very interesting under the Patent Act. The Patent Act clearly defines inventions under section 2. If you look section 2J, it defines inventions, the term inventions, and also in detail it described, or else it defined the term new invention as well. And also in the section 3, sorry. Any doubts?
Mr. Navneet Kumar. Thank you, sir.
Okay, yeah. So now, yeah, it also talks about the new inventions, and also section 3. If you look into the section 3 of Indian Patent Act, it also talks about what are not inventions. So interestingly, the Patents Act, or as the patent, always revolve around the term invention. So first we need to be very clear about the invention, then only you can take forward about your patent applications. Then we can talk about, you know, the patent grantings, commercialization of patents, licensing of patents, okay, whatever it is. But still the first step to go, or else, you know, to file a patent application, we as an scientist, or we as an inventors, or we as an academicians, we need to be very clear about the term, what is an invention, and also whether that invention is a new invention or not. And also that invention is also termed as a not an invention under the Patent Act. It may be a little confusing. I will clarify all that these particular 3 terms under the Patent Act. So normally invention, it talks about, you know, any new product or process. If anything which is completely new, either it can be product or else it can be process as well. Both the products and the process can be protected under the patent systems in India. So if the invention, it talks, as we discussed already, so if it is completely a new product or new process, it can be, it can be termed as an inventions. Now coming to the inventions, what are the new inventions again? So it says that even though it is an invention, so you created something new, right? So we created as an institution, so as an assistant professor or else as a researcher in a lab, what you did is like you created something new invention related to one particular technology, maybe in the four-wheeler with related to the braking system. Let's take into that. Okay, with related to the brake system, you created something new which is not existed elsewhere. Okay, till date it is not existed anywhere. Now what happens is that whether this is termed as an invention, obviously this is termed as an invention under the Patent Act, but whether this get as a patent or whether this passes the filter of patentability, that for that we need to look whether this invention is a new invention or not. So what does it mean? It should not be anticipated by publication, or else it should not be used anywhere, okay, in the world, not only in India. It means that, so you invented something new, but you have published your research paper, right? So before, what you did with your invention is that you have all the studies with related to the braking system. So you have published in a very good journal, and then you published it. Or else what you did, like, you know, you gave an interview, maybe with some media channel, or else you have posted in your LinkedIn post, okay, or else you could have shared in your social media websites, like, you know, in maybe in the Facebook, LinkedIn, etc. Or else you wrote a blog on that. Even though that invention is new, but what happened, even though that is an invention, but what happened here is that you have removed, or else, you know, you put a barrier on that of that invention, as it is not a new invention because it is already published. So it is already anticipated, this invention is already anticipated by publications, or else it could, you already started using that invention in the market. Okay, so it is already used. So prior, it is already available in the market, not only in India, maybe somewhere else in the world. You could have presented, you have created your invention in SOCA college, but what you did is like you presented your research paper in some other conference in Germany, right? So the conference report is already in the public, and then they have published that report in the public domain. Hence, it is already in publication and it is anticipated by the publication, and hence it cannot be termed as a new invention, right? So first and foremost thing, that as an inventors, we need to be very clear about this, our patent and our patents, or else our inventions. Okay, it's not about the patent only, because first you should know that, okay, whether it falls under the patents, or else it falls under the trademarks, or it falls under the designs, etc. So intellectual property is not only about the patent systems. So there are different intellectual property rights. So, but to qualify as a patent, so patent, it should be an invention. So as per the Patent Act, Section 2M of Patent Act, it says that patents for any inventions granted under this act. So it clearly talks about the inventions. Only inventions can be protected under the patents in India, and that inventions should be new inventions. And also that inventions should not fall as not inventions under Section 3, right? So here now we are with the new invention concept. So once your intellectual property right is qualified as an invention, so obviously it is into the patent system. Now you are very clear that you can take it forward under the patent system, but at the same time you should take care that it should not be published anywhere else when you are filing for any patent application, right? You should take care that to prove that it is a new invention. So it means that it should not be used anywhere else, or it should not be anticipated by publication elsewhere in the world. So then only it will be qualified as a new invention, or else it will be objected during the examination stage of patent applications. Even though it is you are the owner of that particular invention, you are the applicant of that invention, and you only publish that patent application, but still it is already published and it is already anticipated in the form of publications, right? Hope we are clear. So first and foremost thing, before jumping into the patents and talking about the commercializations or else granting of the patent systems, we as an individual, we should be very much clarity or clear about what exactly the inventions are and also what exactly the new inventions is. By knowing this, what happens is that you can save a lot of time in your research. So you can save a lot of money during before going for the patent applications or filing any patent applications, etc. From the stage one, if you're clear about the inventions and what are the new inventions and where where and how you should not publish your patent applications, and also what exactly your inventions, whether they're qualifying as whether they're not qualifying as an inventions under section 3 is also we need to look. And coming into the section 3,
sir, again that slides are not moving, I think, sir. It's fixed under now it's in slide 6.
Yes, okay, this is slide 5. Yeah, this is okay, sir. Yeah, thank you. So this are the not inventions. So section 3A to section 3B under the Patents Act. So which section 3 says that these are not an inventions under the Patent Act, even though those are termed as an inventions in general. But as when you're considering for a patent under the Patent Act, these are not termed as an inventions, even though it can be new. It can be something blockbuster in nature and it is completely new technology or new method or new process. But still, if it is causing injury to the humans, plants, and animals, right? So in such inventions cannot be a patentable subject matter. So here the primary and intended purpose of that invention. Now, for example, if you look into all the inventions, for example, you created some, the innovative four-wheeler. So when there is an accident that is caused by an innovator four-wheeler, of course it causes injury to the humans, or else it may cause injury to the animals also, or else the pollution that it is releasing, it may cause injury to the plants as well. So do you think that each and every invention should not be a patentable subject matter? The answer is no. So it clearly states that if it's a primary and intended purpose, the primary and intended purpose is creating injury to the humans, plants, and animals, then in such cases it may not be termed as an invention under the patent, and then the examiner can raise a question stating that this invention is not a patentable subject matter because it is creating an injury to the humans, or else it may be creating injury to the plants, or it may be creating injury to the animals. So here I would like to cite one of the interesting example, that patent application that in the few a couple of years back we filed with related to one invention where the cattle, so they are using the cattle to generate the power. So what happens is, like in one uniform circular mode, so these cattle will be keep on walking, so for the almost like 9 hours to 12 hours of time, and then with that they there is a technology also involved associated with that, and then they are creating a little amount of electricity, right? So here, but to create that, they required animals actually. So they required that animals should keep on walking for a longer time, like 10 to 12 hours of time. So even though there are other alternatives to generate electricity, right? So it is not the only one source where we can create the electricity, and also it is not that a huge amount of electricity that they're going to create it. But here the injury that is causing to the animals is more when we are balancing both the things. So in such cases, it will attract the the conditions, as it is not an invention under the section 3A, which states that it is causing 3B, which states that it is causing injury to the plants and animals. Same way, there are some inventions which are just in discovery, okay, of in living or non-living things. For example, you are just trekking and then you are walking, and then you found that there is a rose flower which is having, it is not only with the one single color of petals, there are multiple colors with that particular petals, and this still now no one could have discovered that. So such discovery where your technical skills are not at all used, So such discoveries are also not, doesn't come under the inventions, and these are not a patentable subject matter. And also coming to the new form of known substances, mainly with related to pharmaceutical products, section 3D, it talks about this. So even, for example, there is a substance that is already used in the market, which is, which is used for one particular element. And then you found that, okay, there is, it can be used as in one more, to treat one more disease, okay? So such new use of that known substance, or else a new form of a known substance. For example, there is an alpha form, alpha is there, and then beta, okay, they're using the beta. And then in such cases also, it cannot be unless there is a significant amount of technical aspects in that, it cannot be patented under the sorry, it cannot be treated as an inventions under the patent system. So, and also like mere arranging and rearrangement of things. For example, you want to invent something where a camera for a two-wheeler vehicle. So what you did is like, so for the two-wheeler, you just I brought a small camera, and then you just affix it to that to the two-wheeler. That's it. Okay. So you're just arranging and then the rearranging the mere existing things, and then hence you are saying that, okay, this is a unique product, and then it is a unique invention. We need to protect it as a patent. These inventions also cannot be termed as an inventions under the Patent Act as per the section 3. And also the results are, there is an results which are resulted merely because of admixtures. That's it. Okay, you are just mixing the water with salt, and then you are stating that, okay, this is a specific concentration of salt that can be that is an an innovative in nature, and then this product can be protected as a patent. Even though that the results that are attained by mere admixtures are also not protected as an inventions under the patent systems. And also the method for agriculture, the method for horticultures. So that particular agricultural practices are also not termed as an inventions under the patent systems. And also the method of treatment. So how, how the surgery performs. So the devices that are used in this medical treatments are protected under the patents, and also can be protected under designs or whatever intellectual property it is maybe. But the method of that particular treatment is not protected under the patent systems. Because these are not termed as an inventions under the Patent Act under section 3. Now coming into the artistic work, so there can be something artistic work or musical works, the creative works. So these are all protected under the copyright systems, and then hence it is not protected, or else it is not termed as an inventions under the Patent Act. And also the method of business, or else the mathematical methods, the way of presentation of your presentations, or as computer programs per se, like the business methods or traditional knowledges. So these are all not protected or else not termed as an inventions under the patent system, right? So even the traditional knowledges, because it, as we said that, okay, there may be the inventions with related to that, but it is already stated that, the prior it is already new that this traditional knowledge is in the practice in such and such, a country, or else it is already, the tradition is keep on continuing, or else it is using. For example, the best example is with related to the turmeric patent. So we all know that the turmerics are used as an to treat small bruises, and also as an antiseptic, right? The turmeric in India. So this is a traditional knowledge as in grandmom's tip with related to a small injuries, etc. But what happened is, like in US there is a patent that is filed with related to the turmeric, and also the patent got granted. So there are like, two Indian scientists, researchers who were working in the US, and then they filed for a patent application there, which stated that, this with only with 2 claims. That's it. So the claims also stated that, okay, this can be used for to treat the surgical wounds. So this is also protected in this is the patent is granted in US with related to this particular traditional knowledge, but it got revoked because we could able to prove that this is a traditional knowledge that is there in use in India from many years. So to prove that, we need to look into the existing texts, or else the existing knowledge that is already there in the public. So that is where actually we found a little bit of we took a little bit of time to prove that where exactly the term for the surgical, they use the term the surgical wounds. So to to counter that surgical wounds, it took a lot of time, but still we could able to successfully revoke that patent application with related to that turmeric patent. So there are many such traditional knowledge inventions that are keep on filing, throughout globally. sorry, to counter that, actually we have TKDL, Traditional Knowledge Digital Library in India. So where all the traditional knowledge details, or as traditional knowledge related inventions are already provided with that, and all the examiners while traditional digital library while granting, or else while examining the patent applications, right? So hence, even though there may be inventions, or it can be qualified as a new inventions under the patent, or else under the Patent Act only, but still there is one more filter that you need to pass, which is known as Section 3 objections with related to what are not inventions. So we need to look under each and every subsection under Section A to Section 3A to 3P, where exactly our invention, or else the invention that what we are talking about is fitting under coming under any such or non-patent the non-patentable inventions which are mentioned under Section 3. If so, then it is not advisable for you to take it forward for a patent filing, because it will be obviously objected by the examiner during the examination report, stating the grounds on that Section 3. Yes. Yeah. So now what are the patentable? So to summarize, actually, so when we are going for a patent, filing any patent application, so there are three important patentability criteria. First and foremost thing is that novelty or newness. So it should be completely new in nature. So how we will know that it is already new? We should prove that it is not nowhere it is existed. Nowhere existed, not only within the jurisdiction of India, but anywhere else in the world, right? So we need to prove that particular prior art is not existed anywhere else. And how can we do that with related how can we prove that? We need to conduct, I mean, like before going for any patent filings, it is always advisable to go for the prior art search. So you can search that already existed prior arts, where even in the previous designs session also you saw that, okay, you can search that particular designs. In the same way, we can search our patents, already published patent applications under Indian Patent Office website, or else there are patent journals that are released every Friday. So in that also there will be information with related to the patents that are published, the patents that are granted, or as that the patents that are assigned, etc. Right? So you can have that. You need to look into that existing published patents, not only in India, or else you can go through this EPO website or else WIPO websites, where you can look into, or else Google patents, a simple search. So you can look into the patents which are already existed throughout the globe on one particular technology, or else the inventions that what you are going to file or protect it under patent systems. Okay, and also that invention should be of utility or usefulness. So it should be capable of industrial applications. So there will be some applications where it is feasible, or else it can be possible only in documentation part. But when coming into the industrial applicability, you cannot manufacture that particular product. For example, there will be an inventions where to get 1% of that particular compound, or else that particular product, there will be like in industrial facilities that should be required is beyond the limit, actually, right? In such cases, the industrial applicability is lacking the industrial applicability, even though it is completely new in nature, even though it is a patentable even though it is completely novel in nature. Nowhere else it is existing, and also it is possible practically with related to the documentation part, but when coming into the industrial application, it is not at all possible. In such cases, these cannot be protected under the patent again. So because it should be capable of industrial application as well. And the one more important criteria is that non-obviousness. So it should not be obvious to the person skilled in that particular art. For example, again, when we are talking about the four-wheelers, a braking system. So when you're filing any patent application with related to the four-wheeler, maybe it will related to the speedometer, or else braking, or else efficiency of engines, whatever it is. Okay. So when that invention can be new, and also it can be novel, but it is obvious to the person skilled in art by looking or reading into that. Okay, it says that, okay, by making that particular small tweaks, a minor changes in the existing knowledge, we can create this invention. So a person, a professor in the mechanical, or else a researcher in the mechanical subject, okay, if he can say that, okay, if he can understand that this is not obvious, okay, so this is just an obvious in nature, and then anyone can create that particular invention. In such cases also, so it is not it cannot be qualified for the patentability as one of the patentability criteria, because it should be non-obvious. So like, for example, there is some solution which many scientists couldn't able to crack that solution from the many years. Okay, even though there are skilled in the person skilled in that particular art are existing. So in such cases, it took a lot of time, maybe 4 or 5 years of time, a drastic time, not just a reasonable time to bring that invention into the market. So in such cases, it can be qualified as, you know, under non-obviousness, and it can be protected, or else it can be passed the filter of patentability criteria. So now we looked only about the patents. So patents are only for the inventions that we all know, and there are some other intellectual property rights, because as a scientist, or else, you know, as an inventor or academician, we always tend to file our inventions or else protect our inventions under the patent system only. So we are little bit, you know, we are in the impression that patents is the strongest protection for our intellectual property, rather when comparing into the design protections, etc. But it is not like that. You know, the categorization is not made accordingly, like, you know, that on the priority basis, but it is based on that intellectual skills, or else, you know, the threshold of that particular inventions, or else, you know, of that intellectual skill, the creation of your intellectual skill, where under particular that on your intellectual skills only, this intellectual property rights are categorized, and then you can protect it if it is qualified as an invention, as we discussed till now. If that invention is completely new, and also if that invention is not an invention under section 3. So in such cases, that particular patents, you can take it forward for the patent systems. And also when you are creating something, a brand name for your product, for your innovative product, like for or else, you know, the company, or else the organization that you are going to start for your you know, for to market your innovative product into the market. So such you know, brand names can be protected as in trademarks, but not, you cannot go and you know, you cannot ask any patent attorney to file as in patent system, and also you cannot protect under the patent. We need to be clear that these can be protected only under the trademarks. And the same way, in the previous session also, you have looked into the design protections. So these designs only talks about the look of that particular product. So the final look of the particular product, how it is, you know, how it can be judged by a sole eye, or else, you know, it can be differentiated by one product to other product. So such designs are protected as in designs, but not the technology, how you're making that design again. So the technology that is involved to come up for that, you know, design into the market is protected under the patent system. But the final end product, that what it is, you know, how you can judge with your sole eye, is protected under the designs, right? And the same way for the copyright for your, you know, literary, dramatic, musical works, computer programs, or else films, artistic works, sound recordings, etc. It is protected under the copyright. And geographical indications, these are mainly, I mean, it is not that you know, important here to discuss, but still it is only with related to the goods that are originated from specific origin, where that origin or else geographical area is contributing to that uniqueness of the product. For example, you know, Chennapatna toys only, or else, you know, Mysore silk sarees, etc. That we are not going in detail with related to the geographical indications. So such goods are protected under geographical indications, but not under the patents or trademarks, etc. Right. And also, if you don't want to disclose your invention related aspects, and then you want to keep it as a secret, so something that it is called as in a trade secret. So you can keep it as a secret, but it is not protected as an intellectual property. For example, there are some recipes, you know, or else the formulas of Coke, Pepsi, etc., which are not still disclosed to the public, because as we said that, you know, patents are patent. To get a patent, you need to disclose all your information. So once you disclose all your information, it is accessible to the each and everyone, right? So when it is accessible to the each and everyone, then each and every person who is skilled in that art can make that particular product by reading your document. Now what the few recipes, or else, you know, few formulas, what they did is like, you know, they are not interested in protecting in the under the patent system, but they are holding it as a trade secret. But one disadvantage with related to this is that it is protected as long as you hold it as a trade secret, but once it is open to the public, or else if someone could able to crack that formula and then discloses that to the public, then it is, you know, that it loses the secrecy, and then it is already into the public domain, right? So that is one advantage and disadvantage with related to the trade secrets. If any inventor doesn't want to go for, you know, protecting as a patent, and if they want to keep that knowledge as a trade secret, obviously yes, they can keep it as a trade secret as well. Now coming into the patents, so patents, as we know that, okay, the patent is an exclusive right. So it is given by, you know, government for a specific time period. So it doesn't mean that once you get a patent, you know, you are having the monopolistic right lifelong on that particular product, or else any that process, right? So but till that time period, limited time period, that limited time period is 20 years from the date of filing. So the 20 years it is calculated. So till 20 years of time, you have that exclusive right to use your invention, right? So you can sell your invention, or else you can prevent someone from importing that invention to the market, right? So this is something as a negative right, because the patent section 48 of Patent Act says that, you know, the rights, exclusive rights of the patentee is that he, without the knowledge of the patent holder, so these rights are exercised after granting of a patent application. Okay, so it doesn't mean that after filing of a patent application you cannot prevent from someone selling or using it. So you need to get a grant on the patent application. So once you get a grant on the patent application, it prevents others from selling or else using your patent application or else importing of your patented either product or process within that territorial limitation, or that is within India, right? So you have, as an inventor, you have an exclusive right on that patent application. You can license it to anyone else. You can, you know, license to n number of people, or else you only can use it, or you can produce that application, the product or process, and then you can start marketing of your invention, or else you can sell your invention to someone else as well, right? So where to register your patent and how to register? So there are a lot of procedures while filing of a patent applications. We will come to that in the coming slides. So where to register, as we discussed even in the previous session also, there are different patent offices in India. There are 4 patent offices as per the jurisdiction, territorial jurisdictions. One is in Chennai, Delhi, Mumbai, and Kolkata. So as per your appropriate office, you can choose your office and then you can file your patent application either online or else even in the offline mode as well, right? How to register, that we are going to discuss. Now patents, these are territorial in nature. What do you mean by territorial in nature? If you protect your patent application in India, you file your patent application and patent is granted in India, then you are protecting your patent in only in the Indian jurisdiction, but not, you cannot claim your patent rights in UK, US, Germany, or China, wherever. Okay. So to claim that rights, you need to protect, or else you need to file your patent application and then you need to get a grant on your patent applications in other jurisdictions as well. If you want to claim your right in UK, then you need to file your patent application in UK. So there are different, you know, there is a convention applications, there is a PCT application process. Okay, we can discuss in detail maybe in other sessions as well, how you can protect your patent application in other jurisdictions. But initially, like if you file your patent application only in India, it is limited only to the territorial nature, and then that rights can be exercised only in this particular territory, that is in India. That's it. Okay. So 20 years, so it is protected from the date of filing, not from the date of grant. So as you know, it may take the patent, the granting of patent may take a time from, you know, 8 months. The fastest patent that is granted, maybe I think 8 months or something for the startups. So 8 months to 9 years, 5 years, 6 years, it may take time. It all depends upon the prosecution stages, examinations or oppositions, etc. Or else how fast you are responding to the examination reports and all. Okay. So ideally, it takes 2 years also to get a patent. Most of the patents are getting granted in 2 years or else 3 years. And then if you're following the expedited process, you may get in within even in 1 year as well, the patent. So from the date of filing of the patent application, so from the first application filing date, 20 years it is calculated, but not the date of grant. So this we have already discussed. So the patents, your inventions are protected under the patent systems, and it should be new or it should be novel in nature with related to product or any process, and also how you can find it with related to the prior art. You need to search all the prior existing art, not only with the patents that are filed, but also non-patented literatures like research papers, or else any publications, or else, you know, even in the mode of videos also, not only with the written format. It could have been disclosed in the form of interviews. It could have been disclosed in the form of presentations, right? This all comes under the prior art, and then you need to check each and every published prior art, and you need to look that whether it is almost similar to the existing knowledge or not. With that, we can establish that how new our product is or how novel our invention is. So now when we go for the patent application, so before filing any patent applications, so you need to be clear about how you are going, I mean, like, you know, what you are going to file or what is your object. Whether are you ready with all complete, invention, maybe with the complete detailed description of your inventions, how it is performing, and also the claims, the technical informations mainly. So if you are very much well aware of that, even though the prototype is not at all required, but still, if you are confident enough to file complete specification with related to full descriptions, etc. And then you can go directly for the complete specification. So when you're going for a complete specification, that should contain title of your particular invention and also the fully described inventions and also the best method of performing. Even it may be the product or it may be the process, and also the claims and also the technical, all the technical informations, or else figures, charts, comparative tables or studies should be submitted with the complete specification when you are filing for any complete specification. And if you are not that clear about the technical information, but you are a little bit aware about your invention, and then you are very clear that within 1 year of time you can submit all the needed information to file as a complete specification. In such cases, what we do is like we can go for the provisional specification. So once we file for the provisional spec, so from that time we have 12 months of time. Within 12 months you can go for you can submit the complete specification. So for the provisional, you need not to go for abstract. Sorry, you need not to go for the claims, but title, abstract, and the details of the applicants, and then the applications, descriptions, etc. is required. But claims generally it is not a requirement for the complete for the provisional specification to file as to file a provisional spec. But still you can provide 1 or 2 claims as well. It all depends upon the strategy that an inventor follows to protect their invention under the patent systems. Right? These are the 2 important things. And then coming to the patent prosecution, the stages that what are there till the grant of a patent applications. The first and foremost thing we need to keep in mind that for one invention, one form and one application is required. Okay, you cannot include 4 or 5 or else multiple inventions in one patent application to save the money, and then you cannot file any patent application. One form of application is only for the one invention, right? So there are specific forms under the Schedule 1 and Schedule 2 of under the patent rules, which talks about detailed description, details of what is the fee that you need to pay. Okay, what are the forms that need to be supported while filing any patent application, and what are the details that are required as per the forms that they do mention, right? All the information should be disclosed in the forms. And also you need to, as I said, that either complete or provisional spec, you need to file with this particular forms, form 1 and form 2. We need to file provisional specification or as the complete specification with the information that is required in that, right? So once the application is filed, so the next thing is that the publication. So generally the patent, after expiry of 18 months, the publication happens automatically. You need not to pay any fee or else you need not to request anything. But there is a provision for requesting for early publication. So you can request for early publication by filing a specific fee that is mentioned under the Patent Act. Okay, there are 2 set categories of fee. So for individuals, it is 2,500 rupees that you will pay for requesting for early publication. So once you request for the early publication, ideally it takes 4 weeks of time, sometimes 5 weeks. It all depends upon the functioning of the patent office as well. But it may not take not more than 2 months to publish it as an under the early publication, right? So once the publication is done, at any point of time, not only after the publication, after filing any patent application, within 48 months of the priority date, within 48 months, at any time you can request for examination. Not only the applicant, any person can request for the examination. Until and unless we request for the examination won't start, right? Same like, for example, if a student, until and unless he pay the examination fee and then he take the hall ticket, he's not allowed to write an exam, right? In the same way, we need to pay that examination fee, and then we need to request that, okay, you can start examining our patent application. So until and unless anyone requests for the examination won't start under the patent. So at any time before 48 months. So for example, if it is early published and then you filed your request for examination before only, so after the publication, immediately the examination starts. Or else, for example, you filed, it is published, and then after 1 year, okay, you would like to now request for the examination, then you can file for request for examination and the examination starts. So once the examination starts, generally within 3 months of time, or else within 6 months of time, you receive examination report. So the examination report states about the grounds on which they have examined your patent applications, and then are there any grounds that they would like to seek information with related to your invention. For example, if it is not novel in nature because it is already existed somewhere else. So they state that these are the patent applications, these are already existed. Or else it comes under section 3. So they state that this invention falls under section 3D or 3A, 3P, whatever it is, as per the section 3 related non-patentability inventions, etc. Or else any formal objections, like for example, you forgot, okay, to mention a title related to your invention. There may be something missing in your title, or else you couldn't able to pay the required amount of fee for the patent applications, or else the claims are not drafted as per the rules that are mentioned under the Patent Act, or else the figures are not numbered, right? So all that formal objections are also raised under the examination report, and a detailed examination report is released, and it will be shared with the applicant and also the patent attorney who filed your patent application. So once the examination report, you receive the examination report, you have a time to reply to that examination report of 6 months of time. Within 6 months, you can reply to your examination report, with a detailed explanation with related to the queries that are raised there. Or also you can extend your reply to that examination for 3 more months actually, as per the patent rules. But beyond 9 months, you cannot reply for the examination report. So once the examination report is submitted with all the details that are required for the patent examiner and the controller, so the examiner and controller goes through that, and then he thinks that if it fits for granting of patent application, your patent can get grant at that stage only. If you think that, okay, still there is a requirement or else lacuna of information that they require, then they call for the hearing. So once the hearing is scheduled, generally the attorneys do attend with all the informations with related to that objections that are raised again in the hearing. So we do reply to that, attend that in the online mode, or else in the offline mode you can attend for the hearing. So once the hearing is done, and then you need to submit your written submissions, and based on that hearing and the written submissions, either your patent may get a grant or else it can reject as well. Okay, so these are the ideal stages, that from the stage of application to the grant. And then in between there is something called as oppositions. So any person can oppose your patent application, stating that, okay, this is already existed, or else there are grounds that are mentioned under section 25 of Patents Act. So 25(1) pre-grant oppositions and also post-grant opposition. Even after granting, within 1 year of the grant, anyone can oppose that patent application. So this is termed as an post-grant oppositions. So the grounds for the oppositions are dealt with section 25 of Patents Act, 25(1) and 25(2). Right. So these are the rights of the patentees. So we have already discussed about the rights of the patentees, that, okay, any third party without the consent of the applicant cannot make, use, or sell, or offering to sell, or using that process, and also he cannot import that patented article within this jurisdiction, right? So these are the fee structures. So one interesting thing is that there are 2 categories of fees. Schedule 1 of patent rules deals with the fee. So for all the startups, individuals, small entities, and educational institutions, they all come under one category. So under this, only the filing fee is 1,600 rupees. So it is almost like 80% lesser than the application fee for other applicants. For all other applicants who are not mentioned under startup, individual, small entity, educational institutions. So for all others, it is 8,000 rupees. This is for the e-filing. 1,750 for physical filing, and 8,800 for the physical filing of patent application, right? And when you file your patent application, there are some limitations, with related to number of pages that you are going to submit it, and number of claims. So generally till 10 claims, there is no extra fee that you need to pay to the patent office. But once the claim, exceeds 10th claim, from the 11th claim, for each claim we need to pay 320 rupees for each claim. We need to pay as an extra fee while filing your patent application for the startups and individuals. So as a startup or educational institution, you are filing any patent application, and which consists of 15 claims. So for that extra 5 claims, you need to pay extra fee of 320 rupees. You need to calculate that as per the claims that you are adding, and then you need to pay it. And for the other applicants, it is 1,600 rupees per claim they need to file. So it is like, one extra claim of other applicants is the filing fee for, for the startups and individuals actually. And coming to the pages, it is limited to the 30 pages. I mean, it is not limited to the 30 pages, till 30. So it is free. The same fee of 1,600 applicable. So beyond the 30 pages for each page, we need to pay 160 rupees for each additional pages that you are going to file. Okay, this is one more thing with related to the fee, and also yeah, under same way it is categorized under each and every category. For example, request for examination. So there is one set category for startups and individuals. There is other category for other institutions, and also there is expedite examination. So even examination also you can expedite it by filing 8,000 rupees for the startups and individuals. So there is even though the examination stage happens a little bit more faster. So like that, and until the end there is a category of two set categories where the file schedule 1 deals about the fee, and the schedule 2 talks about the forms, what are the forms that are required for filing of patent applications, right? So these are details about that, and this is one of the patent application, and that as Sunil sir initially mentioned about the granting of the patent application. So this is how the patent, the certificate looks, right? So this is a new design of the patent certificate. So from April, I think from this World IP date, they started issuing this new uniform patent certificate, where you can see, even there are different languages in the background they have mentioned about this. So in this, we can see the patent number and the application number. While filing the patent application, the application number is issued. So for all other communications, we need to refer this application number, right? So this is the application number that they have mentioned, and the date of filing, and also the person who is the patentee of that invention, and the inventors of. So the details of the inventors and the details of the patentee are mentioned in this, with the title and with the stamp of the date of grant of that patent application, right? So coming to the international, there is so when you want to file any international applications, there is a route called PCT, Patent Cooperation Treaty. So under this, with a single application, you can save the priority in multiple countries for 30 months. And then you can enter into national phase at any time after, within that 30 months of time, or 31 months as per the jurisdictions that are mentioned, right? So I'm not going in detail with related to the PCT and international filings. We can discuss in other sessions, as already we are running, about to close the presentation here. So this is these are the things about the inventions or innovations from the innovation stage, the basic innovation stage, to qualifying, or else terming it as an invention, and also whether it is a new invention, and also we are filtering it as whether that inventions are categorized as an inventions or not inventions under section 3. And then we are taking forward for the patent application and the requirements for the patents. So the details that are required, the fee that for the patent applications, the forms that are required for the patent applications, and the stages that are involved in the patent applications. So this is what we discussed in today's topic. And then next, after filing and after protecting your inventions, then that comes into the picture with related to the commercial aspects. So commercialization of patenting will come into picture after granting of the patent application. So once the patent is granted, then we need to think about the licensings, or else cross licensings. If you are working with some other this inventor who is working in the similar technologies, you can share your license with someone, and then you can cross license your inventions as well. So all that licensing terms, commercial terms, etc., assignments, etc., comes into picture only after granting of the patent. So my suggestion to all the young inventors and academicians is that kindly please keep working on new innovations, and then rightly point out that under which category of intellectual property that your invention fits into, and then you can go forward, take it forward. To have any queries and questions, and you can contact me as well. And now I'm open for questions as well. So if any questions, kindly please unmute, and then you can ask me. Hello.
Yeah, hello. Any participants have a question? You can ask the question to speaker.
Can we get the PowerPoint presentation, sir?
Yes, sir. You can coordinate with the SC college. So I think they will provide. Yes.
Thank you, sir. Or can that one be shared on the WhatsApp group, sir? I'm just curious.
Okay.
So we can actually, recollect what we went, what the session was all about, and all that.
Sure, sir. I think the organizers are right persons to answer on this. Sharing on the WhatsApp group and all on your particular WhatsApp group. Yeah.
Thank you, sir. Thank you.
Yes, sir. So any queries, technical queries related to this patenting or else the patent systems? I think I knew that many of you could have filed already the patent applications. Maybe in the publication stage. Yes.
I'm just curious as to how arts and science background faculties would be able to do
Patent.
To submit a patent or something like that.
Okay. Interesting question, sir. Actually, so this is the question that I'm keep on listening with related to arts and the commerce related background mainly. Sir, as we discussed even in this in this presentation also, patents, intellectual property versus the patents. Okay, first thing we need to look whether are you keen to protect your invention or else creative skills. Okay, so are you keen to protect your innovation skills, intellectual skills? In such cases, whether that intellectual skills are falling under which category, whether is it falling under the patents, trademarks, copyrights, etc. Okay, that is one thing. So as per that, you can protect it. But many of the arts and commerce people, as I already informed, in previous also, many people think that patent is the highest or else strongest intellectual property, right? Or else this is one of the creamy layer of intellectual property. That's what many of the young innovators think about that. Okay. So when we talk about the patents, I already explained about the term inventions. If any invention that you are talking on, okay, as an art, so it doesn't mean that okay you need to keep on working on the art related aspects only, or it's commerce related only. So there can be some technical problems which you can address the technical problems with related to the technological inventions, right? So if you can prove that there is an invention with related to your technical problem that you are addressing, in such cases, let it be art, let it be commerce, let it be whatever technology it is, sorry, whatever technical background it is, we can go for the patent. We can go ahead with the protecting under the patent, and also we can get a grant on that particular patent inventions. Like for example, a best example that I can state is that so there is a professor in the Christ College, okay, English professor. So he worked on biodegradable straws. So his technical skill or his technical knowledge is only with related to English. Okay, he's an English professor there, but he observed as per his observations. Okay, from his territorial area and all, and then he saw that there are a lot of coconut leaves that are it is just like that laying there, and then there is no further use of that coconut leaves, and then he started inventing all this. He created something biodegradable straws with related to that leaf, and it is patented invention, and it is doing very well as a startup as well actually. So it all depends upon what is the problems that you look into. Maybe it can be only with related to your arts, or else with related to commerce only. There can be.
And yes, sir. Now I have a doubt on the same aspect.
Yeah.
So his technical expertise is in he's a language expert. Yes.
Yes.
So how about how did he come about with the technical aspects of it? Because he might not have been very
perfect.
He will not be an expert on physics or chemistry or the making of the whole thing, right?
Understood, sir. Understood. Perfect question. So here, yeah, that's he may or may not. Okay, first thing. Okay, he may be technically skilled. Okay, that is one aspect. Let's think. Okay, let's think that okay, a particular inventor, he's not he had that solution of that, but he's not technically skilled in that. Okay, this is what your question, right? Yeah.
Yes,
so he is not a technical skilled person, but he can take help of the persons who are technically skilled, right? So he can do the collaborative work with some other inventors also. Okay, he can get that the information from other. Sorry.
Okay, sir.
So he can work jointly. It doesn't mean that okay the person should alone keep working on that invention. So there can be a joint patent applications also. So there may be 2 or 3 departments that keep on working on that inventions. Okay, interdepartmental.
So in that case, sir, will the invention or his patent only belong to him or his co-applicants as well?
Yeah.
So it's
So
like
the
a
rights on the
property.
patent, yes, yes, a very good question. So the rights on the patent, when an applicant, when there are a joint applicants, there can be 4 or 5 applicants also. Okay, there can be 10 applicants also. So when there is a joint application on any patent application, so the Patent Act clearly states that the Patent Act only states that the rights on that patent application is equally distributed among all the applicants. So it is distributed equally among all until and unless they have an agreement. Okay. So if they could have signed an agreement before filing a patent application stating that okay, the technical person will have 80% share of that patent application. Okay, the person who is funding this will have 20% of share. In such agreements are there already, then it depends upon that agreement. But if that agreement is not there in picture, then it is equally distributed among all the inventors, all the applicants.
Okay, sir. Thank you. Thanks a lot, sir.
Thank you, sir. Any more questions?
Am I audible, sir?
Yes, sir. Yes, sir. You are audible. There is some disturbance actually from. Can you please
Any questions is there?
Someone is about to ask a question, but there is a lot of disturbance also from others. They're
Am I
unmuted.
audible, sir?
Yes, sir. You are audible now.
I'm Dr. Nagaraj speaking from Dayanand Sagar Academy of Technology and Management.
Yes, sir.
From Computer Science Department, Associate Professor. I would like to ask you, like, which are the things, patent which cannot be patentable, basically, which we cannot patent.
Yeah.
You talked about, and would like to ask you which cannot be patentable.
Yeah. So the section, I think, guests, I think, can you please mute yourself, Bhuvaneshwari? Sir,
Yatala ma'am, can you mute? Bhuvaneshwari ma'am, can you mute?
Yes.
Sir, with related to the non-patentable, that's what section 3 talks about, the inventions which are not, even though those are inventions, but these are not patentable subject matter. So they cannot be qualified as a patent. Now, your question, what is your question regarding with related to section 3?
Yeah, which are the inventions or innovations which can't be patentable?
Yeah, I stated, right? So under section 3, there are subclauses again, section 3A to 3P. So there are different inventions they have described. Like, for example, computer programs per se. These are not patentable subject matter. Business methods, the method of business method is not a patentable subject matter. Traditional knowledge related inventions are not a patentable subject matter. Okay, and also the inventions which are contrary to the humans' health or else animal health and environment are not patentable subject matter. The products which are resultant of mere admixing, okay, these are not, or else merely like you're arranging and rearranging the existing things, these are not patentable subject matter. And also computer programs, as I already mentioned, and agricultural methods, horticulture methods, the way of performing medical treatment, this is not a patentable subject matter. The way of presentation, this is not a patentable subject matter, right? And a mere section 3D, it talks about a substance is already known, but the use you invented new use of a known substance, this is not a patentable subject matter. So under this, there are different set categories of inventions. So even though these are completely innovative in nature, but this is not protected as a patent because these are not termed as an inventions under section 3. Am I clear, sir?
Yeah, sir. Yeah, it's nice to hear from you, sir. I would like to get associated with you.
Sure, sir.
Yeah, I do have some patents with respect to design patents and all those things. Can you just elaborate the significance of foreign patents with respect to the Indian patents?
Yes. Significance of not only with the foreign patents, significance of patents or else any intellectual property, it is twofold. First thing is that whether are you looking for commercial related aspects on that, okay, So for example, patent, already we knew that, okay, it is a territorial nature. So when you're talking about other jurisdiction patents, if you file and protect your invention and then it got protected in other jurisdictions, so no one, same like, and in the Patent Act and as Section 48, no other person or as a third party, until unless you give your consent, they cannot use or sell or make your patented invention. Let it be in India or else even in other jurisdictions also. Okay. So you are having that commercial benefit. So you can start manufacturing of your product, or else you can license it to someone else in that particular country with X amount of, or else whatever the commercials that you are looking into. So this is one of the significance that you are having, right? Next thing is that, one more, as an academician, the significance is that it shows that your research skills are there. Your invention is working, or else, solving some research related, technical related inventions, which is solving some already existing technical problems. So if it granted in other countries also, it is, it is well qualified that it is innovative in nature and it is completely new and it doesn't exist elsewhere, elsewhere in the world. And then hence it is completely new and you are working on in some new technologies. So it shows that, your intellectual skills is also one of the, recognizations to your intellectual skills, as well as recognizations, or else, the commercial values or commercial benefits for your technical related inventions. So these are the two benefits that you do get with related to any intellectual property, not only with the patent systems and in any jurisdictions. Of course, if you don't want to commercialize it, you want to just make it available free for the public, you can make it, you need not to claim any damages on your patent inventions. Okay, you can just make it public to use your patented invention, but still your moral right as an inventor will be always be recorded as, such and such Dr. Nagaraj is the inventor or applicant of that patent application. So such moral rights are always associated with your inventions.
Okay, sir.
Am I
Nice.
clear, sir? Yes.
I would like to get more associated with you in the
Sure, sir.
near future with respect to the patents and all ideas and patent filing and granting, all those things. Thank you.
Thank you, sir. Thank you, Nagaraj, sir.
Hello.
Hello.
Sir, am I audible, right?
Yes, ma'am.
Yeah, you are audible, ma'am.
Yes. Actually, my domain is mathematics, sir. So maximum the theoretical part of work or the solving methods we are applying, right? But
Yes.
How we can file it, sir? For example, if I'm working with the fuzzy logics, and that concept and all is useful in some decision making problems and all, how we can execute that and we will file it that as a patent, sir? Any idea is there too?
Yeah. So, ma'am, I already stated that per se. So, per se means like, primarily, okay, by looking into the mathematical problems, Section 3 clearly states, okay, Section 3K of Patent Act says that mathematical business methods, computer programs per se are not inventions actually, right? Still, Patent Act Section 2 defines about what is a patent and what are the inventions and what are new inventions. So if you can prove that whatever the solutions, what are the technology, I mean, like, what is the problem or else mathematical invention is talking about, which if it is dealing with the technical related aspects, such innovative things, we need to sit together and then we need to look whether it is fitting into the technical aspects, invention aspects, okay, patentability subject criteria. In such cases, we can take it forward for the granting of patent applications. But merely solving any problem, the steps of solving any problems or else, scientific theories, etc., are not patentable subject matter. So how you are using it with related to the technical aspects, okay, how it is coordinating with the technical elements is what important actually. So for that, we need to sit with you. You can sit with any patent attorney. So not only with me, any patent attorney you can sit, and then you need to keep polishing or discussing with related to technical aspects. We need to look about the technical aspects of invention, and then only it can go through the patent system. So I'm talking only about the patent system. So then it can go through the patent system. So, it takes almost like, 1-2 hours to keep discussing about what exactly we need to look into that. It all depends upon invention to invention again, with related to, mathematical problems, computer programs, or software related inventions. So as there is a thin layer that is already provided under Section 3, which says that per se these are not patentable subject matter. So we need to look in detail with related to technical related aspects of that invention. Hope I answered, ma'am.
Anything is there, I will maybe in future I will contact you, sir. Through
Sure,
either
sure.
a mail. Yeah, thank you, sir. Thank you.
Thank you, thank you, thank you.
Is there any other queries from the participant side? If there is no further queries, I request all the participants to switch on camera so that we can go for one group photo.
Gnanateja, sir.
Yes, yes, ma'am. Yeah. Hope I'm visible now.
Yeah, you are visible, sir. Deshpande, sir, is the entire screen is with the participants and the speakers?
So just
From your end, you please check it out, sir. Because sir's screen is shared, we are not able to see everyone here.
Yeah.
Okay, one second.
Then is
Yeah, 1 second, sir. I think, yeah. Oh, sorry, I
No need to say sorry, sir. No need to say, because sir is the main owner of the team. So sir might be getting, I thought, as like you, I also joined. So
yeah, ma'am, I'm getting it now.
yeah, kind request all the people to switch on the cameras. It's a kind of a group photo, what we are taking it for the event. We'll just give one minute time, sir. Let the others also on the camera. Then you can capture it, sir.
Okay. Okay, thank you. Now I request Dr. Nirmala Gupta ma'am to deliver a word of thanks.
So is it my voice is audible?
Yeah, ma'am, you are audible.
Okay, so good afternoon to one and all present here. So it's been a great indeed and a pleasure to propose the vote of thanks. So here myself, I'm Dr. Nirmala S. Gupta, working as a professor and Dean R&D at Sri Venkateshwara College of Engineering, Bengaluru. So to start with a beautiful quote, appreciation can change a day, even change a life. Your willingness to put it into words is all that is necessary. So with this quote, I would like to express my hearty gratitude to both the resource persons of the day for the activity as one-day national level seminar on innovation and IPR. So Mr. Gnanateja Bandi, Research Assistant, DP IIT Chair on IPR at National Law School of India, University, Bangalore, IPR. IP. Arjun MG, Project Associate Coordinator, Kiran IPR Program Coordinator, TISC, KSC, ST. So we are very much privileged to have you both for both the keynotes and answering with very well analogies and the live examples about the innovation patent, the filing process, the costing, everything, sir. So from the entire team of SVCE management, CD, sir, principal, sir, I would like to thank you. So I acknowledge the management and the chairman and the CED sir, Dr. M. Shashidhar Muniappa sir, for his constant support in making all these kinds of activities to be conducted successfully at our institution. So I thank Chairman sir and CED sir. And I would like to give sincere thanks to our motivator, Principal Sir, Dr. Nageshwar Gupta, for his constant support and inputs, guidance in all the aspects of conducting such kind of national level events at our institution. So thank you, sir. I would like to thank all the HODs and faculty members of various departments for their present, and especially the two HODs who took the initiate to conduct such a big numbered participants, external, internal, with very good speakers in the session as Mechanical Engineering Department HOD, Dr. Sunil sir, and Basic Science and Humanities Department HOD, Dr. Srinivas Rao sir. I would like to thank you both. And the team of Mechanical, Basic Science, IQSC, event coordinators, and all other persons who are directly, indirectly work consistently to make this online event a bigger success. So last but not the least, I would like to thank all the external and internal participants from various institutions, universities, agencies, students, faculty members who are invested their valuable time and listening and getting the knowledge about the innovation and IPR. And lastly, I would like to thank the coordinators of IQSC, IIC. As the team, we work towards IPR as one of the milestone and the core component of innovation and entrepreneurship ecospace. So I thank everyone, and I also thank the entire team to providing me the opportunity to propose the vote of thanks. So once again, I thank everyone. Over to you, Deshpande sir.
Thank you, ma'am. I thank you, each one of who participated over here. And your feedback is provided in a chat group. Please fill up all the relevant field so that you can get your participation certificate. If any queries are there, you can post it into a WhatsApp group so that we can send it to our speakers so that we'll convey the answers to you.
Perfect. Thank you, sir. Thank you all.
Thank you. Thank you for everyone.